This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today it's time to talk about catastrophes and the difference between water versus wind claims. The United States Court of Appeal for the Fifth Circuit entered an important decision in 2007 with regard to water damage and insurance policy coverage for claims resulting from water damage and catastrophe losses. In Leonard versus Nationwide, the first of the Katrina cases to go to trial, found that 1. Anti-concurrent-cause clause was not ambiguous. 2. The clause was not invalid under Mississippi law. And 3. Water damages exclusions unambiguously excluded damage caused to a resident from a storm surge. The Leonards' home lied 12 feet above sea level on the southernmost edge of Pascagoula, Mississippi, less than 200 yards from the Mississippi Sound. Hurricane Katrina battered Pascagoula with torrential rain and sustained winds in excess of 100 miles per hour. By midday, the storm had driven ashore a formidable tidal wave, also called a storm or tidal surge, that flooded the ground floor of the Leonards' two-story home. Inspection of the Leonards' residence following the storm revealed modest wind damage. The roof suffered some broken shingles and a loss of ceramic granules, but its watertight integrity was not compromised. The non-load-bearing walls of the garage and the garage door were severely damaged. Doors in the house and garage had been blown open. Finally, a golf ball-sized hole in a ground floor window was likely caused by a wind-driven projectile. Water damage, in contrast, was excessive and extensive. The Leonards' neighborhood had suffered a 17-foot storm surge, causing the entire ground floor of their residence to become inundated under 5 feet of water blown ashore from the Mississippi Sound. Walls, floors, fixtures, and personal property sustained extensive damage. The second floor of the house remained unscathed. The Fifth Circuit found that the anti-concurrent-causation clause unambiguously excluded coverage for water damage even if another peril, such as wind, contributed concurrently or in any sequence to cause the loss. The plain language of the policy left the district court no interpretive leeway to conclude that recovery could be obtained for wind damage that occurred concurrently or in sequence with the excluded water damage. For all these reasons, the Fifth Circuit concluded that use of an anti-concurrent cause clause to supplant the default causation regime is not forbidden by Mississippi case law, including the Hurricane Camille cases, which antedate such clauses. Statutory law or public policy, because the anti-concurrent causation clause is unambiguous and not otherwise voidable under state law, it withstood the claim of the Leonards. To the extent property is damaged by wind and is thereafter also damaged by water, the insured can recover that portion of the loss which he can prove to have been caused by wind, but the insurer is not responsible for any additional loss it can prove to have been later caused by water. The final judgment, therefore, for wind damage was less than $2,000. In a case called Tupaker versus State Farm, the trial court made an important and far-reaching conclusion interpreting insurance policy coverages in the wake of a catastrophe. Judge Center, the trial judge, concluded, quote, "As to the damage caused by wind, there is coverage under the provisions of the State Farm policy because destruction of the insured dwelling by a windstorm, including a hurricane, would constitute accidental direct physical loss and therefore be a covered peril. Thus, to the extent that the plaintiff's property was damaged by wind or objects propelled by wind, the State Farm policy covers the loss. This is also true of damage to personal property inside the insured dwelling caused by rain that entered plaintiff's house through breaches in walls or in the roof caused by hurricane winds." Close quote. Under applicable Mississippi law, the judge concluded that where there is damage caused by both wind and rain, covered losses, and water, losses excluded from coverage, the amount payable under the insurance policy becomes a question of which cause is the proximate cause of the loss. This is, of course, subject to the evidence presented at trial. In Judy M. Geis versus State Farm, a later decision, the trial court was required to resolve a coverage issue relating to damages to property in Mississippi. The judge noted that the plaintiff's principal residence was completely destroyed during Hurricane Katrina on August 29, 2005. She maintained a homeowner's policy of insurance issued by State Farm and in due course filed a claim for, among other things, the loss of her dwelling, including dwelling extension benefits, personal property, and additional living expenses. State Farm denied her claim because damage to her property was caused by wind and flood water. It paid $11,466.39 for the wind damage and declined to pay for any other damages caused by flood. First, Judge Center, again the trial judge, concluded the case is not appropriate for class certification because the nature and extent of the property damage the owners sustained from the common cause, Hurricane Katrina, will vary greatly in its particulars depending on the location and condition of the property before the storm struck and depending also on what combination of forces caused the damage. The denial of class certification rendered moot State Farm's objections to orders entered by the U.S. magistrate judge regarding the type and timing of discovery on the class action. Similarly, in Anthony Vaz versus Allstate, a U.S. magistrate for the U.S. District Court for the Southern District of Mississippi found in a similar case that the plaintiff should be required to file separate complaints. Although plaintiffs each held basically the same standard homeowners policy, each insurance contract is a separate transaction, and each claim is different. The magistrate refused to accept the plaintiff's argument and concluded that they had filed what amounted to a quasi-class action lawsuit. The attempt to join multiple plaintiffs in one lawsuit is an attempt at a class action regardless of the title of the suit. Plaintiffs had attempted to avoid the rigid requirements for class certification and failed to convince the judge that the ploy was appropriate, noting that the same court recently denied an attempt to certify class for Hurricane Katrina cases in Geis versus State Farm. The magistrate felt bound to follow Judge Center's conclusions. Both judges agreed that each property owner in Mississippi who had real and personal property damaged in Hurricane Katrina are uniquely situated. No two property owners will have experienced the same losses. The nature and extent of the property damage the owner sustained from the common cause, Hurricane Katrina, will of course vary greatly in its particulars depending on the location and condition of the property before the storm struck, and depending also on what combination of forces caused the damage. In SC Farm Bureau versus Durham, a 2009 decision of the South Carolina Supreme Court, it found that the insured's damages, which were sustained when rain increased hydrostatic pressure around their pool, forcing the pool out of the ground and damaging their deck, were excluded from coverage because the policy contained an anti-concurrent cause provision that applied to water damage. Because water pressure was one of the causes that forced the pool out of the ground, the court concluded that the water damage exclusion applied. The exclusions found in the policy for water damage and for damages attributable to flooding are valid and enforceable policy provisions. Indeed, similar policy terms have been enforced with respect to damages caused by high water associated with hurricanes in many reported decisions. This video was adapted from my book Selma on Insurance Claims Part 104, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you, please forward it to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. I'd also appreciate any comments you might make with regard to these videos, including this one. Thank you for your attention.